Hello, welcome back. This week's lecture is entitled The Laws of Marketing and Advertising, and I know that it's certainly not the most exciting topic we will discuss in this class. It is what I consider to be both vital and valuable to have a basic understanding of the basic laws of marketing and advertising in the US if you plan to market your products here or, in fact, work in the field. Understanding these laws surrounding marketing and advertising is a major component to understanding the ethics of marketing and advertising. And these laws actually developed out of a common need for the protection of a consumer public and grew directly actually out of a common need to protect the consumer against unethical marketing practices, which makes it ever the more valuable to discuss in the terms of this class. So let's return to a topic we discussed last week, capitalism. And let's recall the definition. I'm quoting. Now, quote, capitalism is an economic system based on private ownership of means of production and the creation of goods and services for profit, end quote. Now, logically, capitalism sounds like a very simple system. We produce goods, we produce services, we charge money, we make profit. Now, it should be an even exchange, and a competitive market, like the one we talked about with the lion and the gazelle, should make for a very value-driven system. So let's talk about the lion and the gazelle again for 1 second. Now, if both wake up running because of this competitive market, what if the balance tips? What if the gazelle encounters, say, a herd of lions? What if the lion never captures a gazelle and the species becomes, say, threatened by extinction? What if outside forces like deforestation ruin their habitat? Now, just as in these instances, the metaphor for capitalism in the free market undergoes challenges that go beyond the simple buy, sell, profit paradigm, intervention is often necessary to ensure fair competition. But does the government and their choice to intervene disrupt the survival of the fittest, Darwinian version of capitalism and the free market? And that's the big question. So let's look at another definition of free market, right? So I'd like you to look and let's read a little bit of this definition right here. A free market is a market system in which the prices for goods and services are set freely by the consent between sellers and consumers, in which the laws and the forces of supply and demand are free from any intervention by government, price setting, monopoly, or other authority. And that's all that I'm going to read. You guys can read the rest of that definition on your leisure. Now, I've highlighted terms in here that I find particularly poignant, and specifically free from any intervention by government and without any intervention by government policy, because these core definitions seem to negate the legal concepts that we will be discussing in the upcoming slides. And for this reason, I find it vital that government intervenes to protect, or to understand that government intervenes to protect the competition and the consumer above all other things. The competition and the consumer above all of other things. Now, while intervention by government in the form of law would seem to disrupt what we would call a free market, it's vital to protect the economy and the consumer above all things, which is what the majority of these laws seek to do. It's also in the best interest of the consumer to have fair competition to protect both the lion and the gazelle. The lion and the gazelle are the way that competition, free market, and capitalism function with a sort of balance. So if we take the previous definition of capitalism and the free market into consideration, intervention by government in the form of law seems just a tad ironic. But to keep the playing field fair, to protect the lion and the gazelle, so to say, it's vital to provide a fair competition. So what's fair competition? Fair competition is governed by rules, by regulations and governmental laws. It's governed by civil and criminal laws, and it's governed, most of all, by public opinion, which is very important to the marketer and the advertiser. And it's governed by the power of the free press. Bad press can ruin a marketing and advertising campaign in a second. So what is unfair competition? Unfair competition is the misappropriation of a competitor's product or mark, a misstatement of geographical origin or benefits, unfair business practices such as fraud, misrepresentation, or trademark infringement. Now, all of these forms of unfair competition are governed by law, and we'll talk about that a little bit in the next slides. So what is competition? Competition, as defined in the business directory, is an open market rivalry in which every seller tries to get what the other sellers are seeking at the same time, the lion and the gazelle, as we say. This includes sales, it includes profit, it includes market share. It also includes offering the best practical combination of both price, quality, and service. And where market information flows freely, competition plays a regulatory function in balancing supply and demand. It's vital to protect competition. Now, antitrust laws are a collection of both federal and state government laws that regulate the conduct and organization of business corporations. And their purpose is to provide fair competition, like we talked about in the previous slide, that is vital to protect at the benefit of the consumers. Now, what are these antitrust laws? These include the Sherman Act of 1890, the Clayton Act of 1914, and the Federal Trade Commission Act of 1914. Now, as I suggested in my previous slides, the scope of antitrust laws in the U.S. vary in degree in which they interfere in what we're calling business freedom. But they remain strong, a very, very strongly and hotly debated topic. Now, while I tip my hat to that debate, I would do it an injustice if I didn't mention the irony that we talked about in the previous slides. We will not delve into that any further in this lecture. We will merely cover their scope, their definition, and their relevance to your work. Now, passed in 1890, the Sherman Antitrust Act prohibits business activities that the government considers what they call anti-competitive. Now, what does this mean? Those acts that prohibit contracts or conspiracies between two or more people or companies that restrain trade unreasonably in any product or service. Also, something that prohibits monopolization, a monopoly, or attempts to monopolize a business, so monopolies. Thirdly, something that applies to conduct within the U.S. and to foreign conduct that has an effect on U.S. commerce. And lastly, those violators of antitrust laws that provide a risk to civil and criminal penalties. So let's discuss an example. In 1998, U.S. versus Microsoft was an antitrust case where Microsoft was actually accused of becoming a monopoly. They were also accused of engaging in abusive practices with regard to their Intel-based computers, their operating systems, as well as their web browser sales. Now, the issue was whether Microsoft was allowed to bundle Internet Explorer web browser software with Windows operating systems. Some of you may remember this court case. Now, in what they called a stinging rebuke, a federal judge ruled that Microsoft Corporation violated the nation's antitrust laws, specifically Sherman, by using its monopoly power in personal computer operating systems to stifle competition. Now, here's a quote from the U.S. judge that actually determined the sentence. Quote, Microsoft's anti-competitive actions trammeled the competitive process through which the computer software industry generally stimulates innovation and conduces the optimum benefit of the consumers, end quote. Now, the settlement pact was reached finally in 2000, where Microsoft and the U.S. Justice Department presented in court a broad range of restrictions on Microsoft business practices, which are now actually common practice in tech today. Now, under the terms of this agreement, Microsoft still actually cannot enter into licensing agreement with PC manufacturers that restrict them from working with other software developers. And this practice is now called what we call exclusive dealing. So with regard to what we just heard and the court case that we just heard about, how many of you have only used one of these web browsers? How many of you used multiple? Now, I ask you this, if the Sherman Antitrust Act weren't in place, would you have a choice? So let's discuss a historical example. In 1908, Henry Ford, American inventor, invented the Model T, an automobile that many middle-class Americans could afford, he was quoted as saying. And he actually revolutionized the American transportation industry. Many of you guys know him as one of the most affluent and the best-known inventors in the U.S. and is credited with developing what we now know as Fordism, an assembly line system to produce mass and inexpensive goods while not compromising a fair wage for workers. Now, with all of Ford's success beginning the American auto industry, would Chevrolet, General Motors, Chrysler, and other international brands like Toyota be able to compete in the American car market without the Sherman Antitrust Act? Is the industry better and more competitive as a result? Are the Lion and the Gazelle still running and still in an active competition? So another antitrust act is the Clayton Act of 1914. Now, this act was actually passed to further strengthen the Sherman Antitrust Act. and it forbids certain actions that are likely to lessen competition once again, although no actual harm has yet occurred. One example of this is price discrimination. The Clayton Act addresses corporate price discrimination. Now, this prevents companies from engaging predatory lending that might lessen competition or create a monopoly. For example, a company cannot have two different pricing strategies in different towns, depending on the competition, using higher prices from a town with little competition to fund lower prices in a town with more competition. However, after this provision was widely used in the 60s to stop price discrimination, stricter standards were also developed. Also, an example is exclusive deals. Now, the Clayton Act also prevents companies from selling products with the condition that the buyer can only use their product. For example, a company that provides copy machines cannot also be the sole supplier, the only supplier of ink and paper as well. This creates a monopoly on the product, and it's hard to prove actually, however, as sometimes the reason for the exclusive deal may be actually legitimate. In addition, some companies may need exclusivity to ensure that customers are getting the quality product that they expect when they make a purchase, which makes it a very, very interesting market. So the Robinson-Patman Act of 1936 actually makes it unlawful to discriminate in prices charged to different purchasers or different consumers. Now, this law was actually enacted in large part to protect the so-called mom and pop shops and grocery stores against larger companies. Now, while there are limited exceptions to this general prohibition, quantity discounts are essentially illegal unless all competing customers or purchasers can take advantage of the discounts. Now, what does this include? This act actually applies to commodities, but not to services, and to purchases, but not to leases. The goods also must be of like grade and quality. There also must be likely injury to competition. And normally, the sales must be in interstate commerce. The sales must be across the state line. Now, this actually began as an amendment to the Clayton Act. So as the Sherman Act was amended, the Clayton Act was amended as well. Now, to place this law in a historical context, if you go back after American Civil War ended slavery, in 1890, the U.S. enacted a series of laws which we now know as Jim Crow laws. These Jim Crow laws were the enforcement of what we call a separate but equal status for African Americans. Now, they're now considered very, very racist laws because they forced the newly freed African Americans to drink from, say, separate drinking fountains, to use separate bathrooms, to sit in the back of public transportation. And this series of laws actually led to a drastically inferior and separate conditions for U.S. African Americans. Now, these laws actually continued until 1954, where we now know that the Brown versus the Board of Education determined them unconstitutional and were disbanded. That said, if racism, segregation, and inequity ran rampant in the country following the Civil War, what could potentially happen if the Robinson-Patman Act hadn't been developed and enforced? Could businesses potentially charge for goods based on social discrimination, based on dislike of a particular individual or race? Now, it is because of these antitrust laws that the U.S. also saw a need for a larger governing body and developed the FTC, or the Federal Trade Commission, in 1914. Now, the FTC initially began as a group of 5 members that were appointed by the President of the U.S. for 5-year terms. The FTC was also authorized to regulate and correct unfair methods of competition through marketing and advertising, which it might include white lies, puffery, switch and bait, which we'll talk about in the next couple slides. The FTC actually is the sole governing body that determines if an ad or marketing is deceptive. Now, what is a deceptive ad, according to the FTC? A deceptive ad is defined as having one of the following. Right, number 1, a false testimonial or endorsement. 9 out of 10 doctors may or may not recommend this toothpaste. Number 2, an indication that a product possesses certain characteristics that it actually doesn't. Number 3, an untrue statement of price or an offer. Number 4, non-disclosure about an important aspect of a product. Number 5, ambiguous statements that actually may appear true. And lastly, unbelievable claims by an actual salesperson. Now, outside of antitrust laws, consumer protection laws look to watch out for the health and safety of the consumer, so all of us. Consumer protection laws include the Consumer Protection Safety Act of 1972 and the Consumer Protection Act of 1976. Now, of 1972, this law was actually established by the Consumer Product Safety Commission, and it protects the public, or you, against unreasonable risk of injury and death associated with products. Now, the one in 1986 protects against marketing of goods, services, and behaviors that are actually hazardous to the consumer. It states that the public has a right to be informed about the quality, the purity, and standards of the product that they're actually purchasing. It assures access to a variety of goods and services at competitive prices, as we discussed before. And it assures the right of the consumer to be heard and to receive due consideration if you're dissatisfied, perhaps, with the product. It ensures the right to consumer education. If you need more information about a product, you should go and get it, and you have the right to. And it respects the privacy of the consumer. And another law outside of antitrust law is the Telephone Consumer Protection Act of 1991. Now, I don't know how many of you remember, but telemarketers, or people who called trying to market a product, could call your home at any hour of the night until this law. Now, the Telephone Consumer Protection Act of 1991 ensures and establishes procedures to avoid unwanted telephone solicitations. It has a limited time of day that telemarketers can call residences. They can't call you at midnight trying to sell you a light bulb, so to say. And companies must maintain what they call do not call lists, meaning if you ask or request as a consumer not to be phone called to receive marketing for a given product, then you have that right. They have to keep a do not call list and not call you again. It is illegal. Now, this slide is just a fun slide that provides a couple of examples of goods that have actually been outlawed by consumer protection laws. They've been deemed unsafe. And I actually remember playing with some of them as a kid, such as marbles or little poppers. And some of you may remember these nostalgically from your childhood, but now they're considered unsafe and have actually been outlawed by the very laws that we've just talked about. So how does the FTC actually determine if an ad is deceptive? Now, the FTC actually looks at the ad from the point of view of what they consider the reasonable consumer, the typical person looking at an ad. So take a look at some of the ads and products you see here, and you'll recognize some of these products: a Big Mac, pomegranate juice. Do any of them seem, or their advertisements seem deceptive, or do they seem to be advertising falsely in any way? So here's another example. I'd like you to take a minute and view the YouTube link. The link is actually available under your weekly folder in Canvas, or you can type it in here. Now, the Ab Glider was an exercise machine advertised with a testimonial by celebrity Elizabeth Hasselbeck. I'd like you to take a break and watch the video now, and it's not very long, but it'll be good to break up from hearing my voice read laws and definitions to you. So does the Ab Glider actually seem to be offering a truthful representation of its product? The FTC did not think so. And in 2014, the FTC announced that Icon Health and Fitness has agreed to pay $3 million to settle charges because of its Ab Glider. They stated that it violated a previous order related to unproven exercise equipment claims and that their testimonial was false. So another term that an ethical marketer should know and be able to reference is called puffery. Now, puffery is a legal term that refers to promotional statements or claims that are subjective rather than objective. Here's an example. The world's best cup of coffee. I know we've all seen that sign. Now, another example. Our service can't be beat. Can it really? That's not necessarily true. Now, puffery is actually a statement or a claim that is very, very difficult to substantiate or to be proven, essentially. Bait and switch is actually common in retail sales and can be considered, and this is important for you to know as marketers, it can be considered fraud. Now, what is bait and switch? Bait and switch lures in customers by advertising a product or a service at an unprofitably low price. And then it actually reveals to customers that the advertised item is not available, but that a substitute is. Now, its purpose is actually to switch the consumer from buying the advertised product in order to sell something else, usually at a higher price. Now, you may have seen actually car ads do this a lot. A car ad may say something like, a Toyota Prius fully loaded is offered for $18,000. And when you go down to the lot, only one of these cars is available at this price with this fully loaded car. And that's to get you basically on the lot so they can sell you something else. Another example, a gas station advertised unleaded gas for $2.85 a gallon, but there's only one pump available with this price. And this is called bait and switch. Now here are the last of the definitions. Now a loss leader is when a product is sold at a lower price, which can be at cost or below cost, in order to attract consumers to purchase other products that are actually at more profitable margins. One example is 7-Eleven. I think we all know 7-Eleven convenience stores. Now 7-Eleven will typically sell milk at a largely cheaper price than most grocery store chains as a means of attracting customers to purchase additional items. You also see a lot of free deals. Now, free indicates that a purchaser is told that an article or an item is actually free to him if another article is purchased. Buy one, get one free, or 2-for-1 sale. Instead of stating that these two items, 1 + 1, is actually this price. You also have the reinforcement of false beliefs. One example of that would be Walmart's recent slogan. They used to state that their slogan was always the low price, always. But is that actually true? Can somebody actually beat their price? And actually people proved them wrong. They could beat their prices. So they were forced to restate a different slogan, and their new slogan was save money, live better. Just an example. And the last example is predatory pricing. Now the predatory pricing is the practice of a firm selling a product at a low price with the intent of driving competitors out of the market, or essentially creating a barrier to their entry or their competitors' entry into the market, or preventing any capacity for new competitors to enter the market. Now, one example, again, is Walmart. Now, is Walmart, the world's largest retailer, guilty of predatory pricing? Are they trying to get rid of the small business, so to say? Now, many customers actually want to purchase products at the lowest price. Is this Walmart's strategy? Now, how can a smaller business actually survive against a price-driven competitor like Walmart if they are, if part and parcel their marketing strategy is to include predatory pricing? So how does that affect us in this actual class? Now, everybody here will be forced at some point in their careers in marketing and advertising to make a decision based on their own ethics, both in their personal lives and in their marketing or advertising corporate career lives. Now, why do we make ethical decisions? What are the consequences of these decisions? These are questions that I want you to think about as we go through the course of this class. All of these laws were produced as a result of what the FTC considered unfair marketing practices, unethical marketing practices. Now, do you want to be the person or the reason that the next law is actually created? And these questions are important to consider. How does it impact our daily lives? How does our marketing or advertising choices impact the daily lives of us as consumers or the consumers of our products? Are we becoming a trusted resource? This will be vital to the next and upcoming lectures. How do you create a company that your consumers trust and value? And what do we need to do when making an ethical decision? Now, marketers and advertisers are actually faced with the task of making their product look the absolute best it can to the consumer and selling it and lots of it. So the temptation to unethical in marketing advertising is a very, very alluring one. I've encountered it, and you, I'm sure, have too. But it's because of this allure that a course like this that you're in right now and laws like these exist, because business leaders know that there's a lion and a gazelle, and that if they don't do something first or get there first, advertise first, then their competitor might. And that's where unethical marketing practices happen and start. Now that's this lecture. I'd like you to please check the announcements section of Canvas for your homework this week and continue to work on your final project, which is due the final week of class. I hope you have a great week, and I'll talk to you again next week.